request all the participants to mute your mics. Meanwhile, please.
You are also muted. Sir, go ahead. Yes.
Good evening to all of you. We have finished up to Article 30. Today, Article 31, 32, 33, and 34 go together, or 35 also go together, or 36. Article 31 to 36 deals about promissory note, bond, payable on payable by installments, or how it is payable. If you see the wording of the promissory note, on demand or order, that means at any time it has to be paid. And the period of limitation for promissory note and bill of exchange is even if the time is fixed within that time or within a period of 3 years. This 31 to 36 almost has a repetition, or even 37 also has got the same repetition. That is, 3 years period is provided within which a suit can be filed. That is, as far when the amount becomes due. Then 38, of course, it's only of academic value. That's the reason why I'm not dilating much on that. Then even 38 is a promise note given by the maker to a third person to be delivered to the payee after a certain event should happen. That is, 3 years period is given. Suppose, let us say, the promise note is given to some person, and after certain event is specified, and after that event happens, and within 3 years, a suit can be filed. So the basic thing of 31 to 38 is that as far as promissory note or bill of exchange is concerned, whether time is fixed for payment or time is not fixed for payment, a clear period of 3 years is provided within which a suit has to be brought. And beyond 3 years, a suit cannot be brought. It will be barred by limitation. Then 39 deals with on a dishonored foreign bill where protest has been made and notice given. As far as a foreign bill is concerned, you have to give a notice. What is a foreign bill, sir? Foreign bill is a document which is executed in a foreign country which is sought to be enforced here. The question is, notice has to be given saying that the foreign bill has come. Please try to make the payment. Then in that case, within what time you have to bring the suit, sir? You have to bring the suit within 3 years period. So in all this, 3 years period is consistent. Then the Article 40 says by the payee against the drawer of a bill of exchange which has been dishonored by non-acceptance. As far as a bill of exchange is concerned, it's a tripartite document where there is a drawer, drawee, and payee. And here, suppose, let us say, the instrument is presented for payment and gets dishonored, and the payee does not get the money. Then, in that case, it is also 3 years. The date on which the refusal to accept. Please remember, the payee does not accept it because there are no funds provided to see that the payment is made. Then it amounts to dishonor. Then, in that case, if the payee has to bring a suit, he has to bring it within 3 years. If you want me to go article by article, I'll go, sir. Or else, only the important provisions I'll deal with, which comes to us in real practice. But anyhow, since it is there, we are going by article. That's the reason why I'm dealing with that. Then Article 41 says, by the acceptor of an accommodation bill against the drawer, then 3 years when the acceptor pays the amount of the bill. So within 3 years is acceptor. Who is the acceptor, sir? The acceptor is the payee. The question is, suppose, let us say, an accommodation bill is given and it is dishonored within 3 years, at any time the suit can be brought. Then by a surety against the principal debtor, I tell you, as far as law of guarantee is concerned, the liability of a surety is coextensive with that of the debtor. But if the creditor sues both the debtor as well as the guarantor, and the guarantor makes the payment for and on behalf of the debtor, then in that case, whatever amount he has paid to the creditor or to the opposite side to whom amount is due by the debtor, he gets subrogated, he gets substituted in the place of the creditor, and whatever amount is paid, he can recover it from the debtor within a period of 3 years. And this in law in the Transfer of Property Act, we dealt with it by saying its contribution, where the surety pays the amount for and on behalf of the principal debtor, the amount which is due by the debtor to the creditor, and that amount which is paid by the surety for and on behalf of the principal debtor, because the principal, the liability of a surety is coextensive with that of the debtor. Then, in case if the creditor is fully paid, all the securities had by the creditor automatically gets passed on to the surety who has paid the money, and the surety is entitled to recover that money or reimburse the money which he has paid to the creditor to discharge the debt. The next one is Article 44. Then, I'm sorry, by a surety against co-surety. Please remember, instead of recovering the money from all the sureties, one surety is asked to pay the entire money, whatever money he has paid on behalf of the other co-sureties also, that proportionate amount which he has paid on behalf of B, C, and D, who are also the guarantors, that money can be recovered by the surety who discharges the debt of the creditor, and he can claim the proportionate amount from the co-sureties even for that 3 years period is mentioned. Then 45 deals with the policy of insurance when the sum insured or payable after proof of the loss has been given or received by the insurer. Then suppose, let us say, the goods are lost in transit, and let us say there is a damage. As far as the consignee is concerned, as who can sue for the money, sir, from the insurance company? It is the consignee. The consignee can bring a suit against the insurance company who has not paid the money, even though it is due, and even though the claim is made. Then within 3 years, at any time, a claim can be made by the insured against the insurer. That is 3 years period. Then by the next one is 46, deals with under the Indian Succession Act, section 36 or section 30, yes, section 361, 360 or 361, to compel a refund by a person to whom an executor or administrator has paid a legacy or distributed the assets. That is under the Succession Act, to compel a refund by a person to whom an executor or administrator has paid a legacy or distributed assets. So, as far as who is an executor, sir? Executor normally arises in the case of a will. In executor is a person, is defined as a person who implements the will of the deceased, and an executor who has paid the money as per the legacy to distributed the money to all the legatees. Then in that case, if any wrongful payment is made, then the executor can recover the money within 3 years, the entire amount whatever has been paid for and under the will. The executor can file a suit within 3 years, the date of the payment or distribution. Suppose the payment has been made wrongly, distribution has been made wrongly, there's a mistake on the part of the executor. The executor can bring a suit, reclaim that amount, ask for refund of that amount, whatever has been distributed to the beneficiaries. And this is Article 46. And within 3 years, at any time, the suit can be filed by the executor. Then the next one is 47. For money paid upon an existing consideration which afterwards fails. Suppose money has been paid on an existing consideration which afterwards fails. Suppose the contract fails, and let us say money has been paid, then that money has to be refunded. Even the specific relief fact, suppose a specific performance cannot be granted, then in that case, money is had and received by the vendor has to be returned back, and a suit can be filed within a period of 3 years. Then the next one is the 48 is for contribution by a party who has paid the whole or more than his share of the amount due under a joint decree, or by a sharer at a joint estate who has paid the whole or any of the or more than his debt share of the amount or revenue due from himself and his co-sharers. Suppose one of the co-sharer pays the entire amount due towards the land revenue, or in Urdu it is called the nuzul, or he has paid the debt on behalf of the other sharers also. The other sharers will have to contribute their proportionate contribution towards their share, and this person was paid wholly or in partly, that amount he can recover from the other sharers. Then, sir, 49 deals with by a co-trustee or to enforce against the by a co-trustee to enforce the estate of the deceased trustee a claim for contribution. Suppose all the trustees are liable, then in that case, one of the trustees pays the entire amount, and one of the trustees on whose behalf he also pays, he can institute a suit against the legal heirs to reclaim that amount what has been paid in excess. And for that also, 3 years period is given. All these things don't arise in real practice, sir. They are only for academic consumption. Then Article 50 deals with by the manager of a joint estate if an undivided family for contribution in respect of a payment made by him on account of the estate. Suppose, let us say, a manager who pays the money much more than what is due. Then, let us say, the people who are forming part and parcel of that Hindu undivided family or HUF are bound to reimburse him the excess amount what he has paid proportionate to the shares held by them, and for that the co-trustee who pays the money is entitled for reimbursement. This is what Article 51 says, and when the that is Article 51 is a co-trustee. Then next one is for arrears of rent. Suppose the tenant is due rent, he has not paid, and for what period you can claim, sir? You can claim only for 3 years period. More than 3 years, you cannot claim under Article 52. This is a basic thing, fundamental thing, which every one of us know. But sometimes when it comes to real practice, we just scratch our head. Please remember, whenever you are unsure about a provision in the Limitation Act, kindly look into the Google. You will get all the sections. You need not just ask your neighbor, ask your senior, sir, you have got the table, you have got the book. Look into the book and say that, and search. Please have the patience to search. When you search, nothing is not unavailable. You will have to only use your brain and use your common sense. Then Article 53, by the vendor of immovable property for personal payment of unpaid purchase money. Suppose, let us say, by a vendor of immovable property for personal payment or unpaid purchase money. Suppose, let us say, the sale transaction is for 20 crores. Out of 20 crores, 15 crores has already been made, and the other 5 crores is due and payable. Then, in that case, the seller can bring a suit for claiming the balance of the amount within a period of 3 years. For everything, it is only 3 years, sir. Then 54 deals with for specific performance of this I want to give a detailed explanation, sir. Article 54 is a very important article, sir. In our day-to-day practice today, the suits which are filed in the court are suits for specific performance. Under what provision you file a suit for specific performance, sir? It is section 10 to 24. Normally, it is filed under section 10 or section 12. What do you mean by specific performance? Specific performance means once there's an agreement of sale or once there's an agreement between intercede parties, there must be a methodology through which that agreement has to be enforced both in the spirit as well as in the letter. And that is the reason, sir. Specific performance, various provisions have been provided. Gone are those days when you just make an agreement just for fun's sake. You make an agreement, both you as the vendor and the other person as the vendee have got the right of enforcing the contract. And that process of that methodology through which you get the agreement enforced in a court is what is called specific performance. I've already dealt with it when I dealt with specific relief act. The ingredients of section 10 is, please remember, section 10 has undergone an amendment in 2018. That's the only amendment that has been brought about in the law relating to specific performance. Previously, What are the two ingredients which have to be satisfied to maintain a suit for specific performance under Section 10 of the Specific Relief Act? It is said that it is based on two equitable maxims. One who comes to equity must come with clean hands. That is, there shall not be any suppression, there shall not be any distortion, there shall not be any concealment of material facts. That is what is called coming with clean hands. Second one is one who seeks equity must do equity. Once you want to knock at the doors of the civil court and ask for specific performance, the question is your conduct should be above board, and you have performed your obligations. Rest of the obligations you are ready and willing to perform your obligations, and there's an essential ingredient as laid down in Section 16 of the Specific Relief Act. And the next one is that is, as far as specific performance is concerned, you don't have a penny in your pocket, but still you say that you want to purchase the property worth 50 crores. You have not even 100 rupees in your bank. Then, in that case, specific performance is normally refused. But Article 54 is a provision which says within what time a suit for specific performance has to be brought. Suppose in the agreement of sale, it is mentioned that normally it is 3 years if the date is fixed. Suppose let us say today we are on 15/6/2024. Suppose let us say the balance of the sale consideration has to be paid within 15 days. That is on or before 1st July 2024. That means time is fixed. That is, you will have to make, in order to be entitled for specific performance, the period within the period for which is fixed for payment has to be clearly paid. Without that, you cannot ask a relief of specific performance. But even then, the question is here, sometimes we have to look into the law of contracts also, sir. Section 61 and 62 of the contract deals with discharge of contract. There are various provisions, sir, how the original contract gets substituted. One of them is novation, another is remission, another is alteration, and another is modification. What do you mean by that? Suppose the contract is made on 15th June 2024, and let us say the payment has to be made on or before 1st July 2024. But the vendor does not insist on the time. He receives the money on 15/9, he receives it on 15/10, he receives it on 15/12 also. That means indirectly, impliedly, the original contract has got extinguished and a novatio contract has come into existence, or a new contract or a nascent contract has substituted the original contract. What is the contract you have to perform, sir? The obligations that are laid down in the new contract alone has to be performed, and the obligations under the old contract need not be fulfilled. Our second thing also can arise, sir. Suppose, let us say, it is an agricultural land which is agreed to be sold. Then in that there is a clause normally included that the vendor shall get the land surveyed by the revenue department and also get it localized, fix the boundaries, and also fix the cuddy stones, and also clear all the government dues, or all clear all the government permits, and obtain all of them, and intimate the vendee. And as soon as the vendee is informed, he shall execute and register the sale deed. Please remember, getting a government clearance is not that easy. It takes about 8 months or 7 months or even 9 months. Then subsequently, if everything is over, then the vendor has to inform the vendee, I have fulfilled my part of the contract, I have obtained all the permissions, I have obtained all the clearances, I have also got the land surveyed, and this is a survey report. And when all his obligations are completed, he informs the vendee that the condition that is imposed under the agreement of sale is fulfilled. Then when does the period start, sir? The period starts when all the purposes are accomplished, or when the jobs are over, clearances are obtained, permits are obtained, or government permission is taken, everything is taken. From that day, it may on 15/6 means it is obtained on 15/1/2025. Then the period starts from 15/1/2025 and not from the date of the original agreement. That means time will not be considered as the time is not the essence of the contract. That is the reason, sir, when a clever advocate is there, like you people, you write a clause there The vendor hereby agrees and undertakes to execute and register. Please follow this sentence, please. The vendor hereby agrees and undertakes to execute and register the sale deed after receipt of the balance of the sale consideration and as and when called upon by the vendee. As and when called upon by the vendee means time is not the essence of the contract. You can take the protection of section 55 bracket 2 of the Transfer of Property Act, which says as far as transactions relating to immovable property is concerned, time is not the essence of the contract, but the period normally fixed is 6 months, 3 years from the date of agreement, unless otherwise provided. Then, for that, what we do is there is one proviso under Article 54. Article 54 proviso says within 3 years from the date when the refusal by the vendor comes to the notice of the vendee, or the vendor has dissociated himself from executing and registering the sale deed, then from the day when the refusal comes to your notice, 3 years period is given. So when you draft a plan, as far as specific performance is concerned, please be very, 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 very careful. You devote a paragraph to say, sir, the original agreement was made on so and so date, and the vendor agreed and undertook to execute and register the sale deed after obtaining the necessary clearances, permits, and from the government, and also get the land surveyed by revenue department, get the land surveyed and localized, and the boundaries fixed, and the cutty stones also fixed to identify the property. And since that has been provided, the period gets extended. And you say, though the original contract was on 15/6, it has taken 6 months time for the purpose of getting the necessary clearances. Then Article 54 proviso says it is safer for an advocate to give a notice to the opposite side saying, sir, you have obtained the clearance only now. I am now prepared to get the sale deed executed and registered by you. Then please come and execute and register the sale deed. And the vendor is under the impression that the time has got barred. Please remember, 54 proviso says if the vendor keeps quiet, does not give any reply, then in that case, the 3 years period starts running from the date of your notice. You come squarely under Article 54 proviso. But these things have to be specifically pleaded and alleged by you in the plate. And in the limitation paragraph also you say, sir, the plaintiff submits that the original agreement was executed by the defendant in favor of the plaintiff on so and so date. And the defendant undertook to obtain the necessary permissions, get the land surveyed, fix up the boundaries, localize the property, and also inform me. And 6 months' time has been taken for the purpose of localizing the land and also fixing up the boundaries. And also, I gave a legal notice calling upon the defendant to execute and register the sale deed, and he has not done so, hence the suit. So you come squarely under Article 54 proviso. So to come under Article 54 proviso, your pleading should be very, very clear. That's why Article 54 says when time is fixed for performance is 3 years from the date of agreement. If no time is fixed, it is any time within even after 3 years also, provided you give a notice. Or suppose novation takes place, alteration takes place, modification takes place, or variation takes place, a supplementary agreement is executed, the original agreement goes. This has to be clearly pleaded in your plain. Please remember, don't avoid mentioning it. Though it may take time, please think over it and write. And also you say the vendor agreed and undertook to execute and register the sale deed as and when called upon by the plaintiff, and the plaintiff gave a legal notice calling upon the defendant to execute and register the sale deed, which he has not done so, hence a suit. So if you want to come under Article 54 proviso, all these things will have to be clearly pleaded. Then the prayer clause, whenever you write a plaint, there you'll have to say the plaintiff therefore prays for a judgment and decree against the defendant as follows. One, for specific performance of the agreement of sale dated so and so, and to compel the defendant to execute and register the sale deed in respect of the schedule mentioned properties. Number two is on the failure of the defendant to execute and register the sale deed, the court may be pleased to execute the sale deed for and on behalf of the defendant in favor of the plaintiff. Then C is, of course, cost, so on and so forth. then of course you know how a plaint is drafted. So please remember, if you want to come under 54 proviso, the necessary ingredients will have to be satisfied. And that is the reason you, as a clever advocate, what you should write is as and when called upon. That means I can call upon you at any time. Then time is not the essence of the contract. And later on, even after the fixed date payments are received, it amounts to what is called novation or substitution of the older contract by the new contract, and the obligations of the new contract alone has to be performed. The old contract gets extinguished. This I've discussed it in detail also when I was dealing with specific relief act, but since it has come in the limitation act, it is my duty to deal with that. Please remember, specific performance suit is as easy but as difficult also. If you step into the shoes of the defendant will take all pleas and all contentions and all possible. You have to be in a position to meet them. Why I'm trying to tell you is, now the coming to the amendment in 2018. Previously, there is a maxim called UB jus, EB remedium. UB jus, UBI space, jus, JUS space, UB jus, EB, IBI space, remedium, REMEDIUM. That means wherever there's a right, there is a remedy. But as far as specific performance is concerned, it was earlier a discretionary remedy. It doesn't mean that immediately you file a suit for specific performance, the court has to grant you a decree. No, you have to satisfy the court that all the ingredients of section 10 or 12 has been complied with, and section 16, whether you are ready and willing to perform your obligations, or whether the equitable maxims, one who seeks equity must do equity, one who comes to equity must come with clean hands, whether all of them are satisfied, and whether your conduct is above board and you have performed your obligations, so on and so forth. All these things will have to be proved, not only alleged, but it also has to be proved. And it's safer to give a legal notice, because the question is, you can know the defense of the other side. You may ask me a question, sir, why should I give a notice? But the advantage of giving a notice is you put the other side on notice to say, look, you have executed an agreement, please perform your obligations. I am ready and willing to perform my obligations. I am prepared to pay the balance of the sale consideration at any time. Please come to the registrar office and execute and register the sale deed. Then you please remember, you come. And whenever there's an overture contract, please try to plead and allege, and also state in the plain that this is how the original contract has got substituted by a new contract, or the original contract has got varied, or the original contract has got modified, so on and so forth. You will have to clearly mention, and also say that you have given a legal notice to the opposite side to perform his obligations, and in spite of that, he has not done so, and you have no other alternative than to file the present suit. So that's why I wanted to give you that explanation as far as Article 54 is concerned. Then 55. For compensation for breach of the contract, express or implied, not herein specifically provided. For compensation for the breach of a contract, express or implied, not expressly provided. Suppose, let us say, sir, I told you also, we don't make a agreement just for fun's sake. Then in that case, suppose the other side is a wrongdoer, you are the victim, and it has not been provided for under any of the provisions of law, then you are entitled for damages, or what is called compensation, and that amount can be claimed within 3 years. And normally, to be on the safe side, what they do is, in the agreement of sale itself, they write, in case the vendor violates the terms of the agreement, he is liable to pay rupees 5 lakhs towards liquidated damages for non-performance of the contract, and that amount can be recovered from the other side in addition to your specific performance. So if it is not provided, you are definitely entitled for compensation. Article 55 says you can bring a suit within 3 years. The next one is, we go to the next chapter, sir, that is suits relating to declaration. This I want to dilate more, sir, because day in and day out, suits which are filed in the civil courts are suits for cancellation of instruments, and for declaration, instrument and decree, and also for declaration for various reliefs. Here, first and foremost is, in the Contracts Act, it is said we have got three types of reliefs. One is contract is void, contract is voidable or contract is unlawful. What do you mean by void contract? Void contract means it's a nullity. When does it become a nullity, sir? There when there is no consideration, when there is failure of consideration, or when it is not binding on it has been executed through force, coercion, undue influence, misrepresentation, mistake, unilateral and bilateral. Then in that case, a contract is supposed to be void, or a contract entered into the minor, or a contract entered into with a person of unsound mind, or a person who is an idiot, or a person who is disqualified under any law for the time being in force, then those contracts are supposed to be void ab initio. And suppose there is no consideration at all, a contract without consideration is a nullity and it's a nudum pactum and it is void ab initio. Ab initio means right from the beginning. That is one type. Second type is voidable. When the consent of a person is not free, when consent is of two types. One is consensus, that's what they call it as consensus ad idem. That is, both the parties should agree upon the subject matter, number one, and the person with whom you are contracting for. These are the two things which constitute a valid consent. Suppose one of them is absent or the other one is absent, the contract is voidable. Voidable means exercisable or avoidable at the option of the party whose consent is not free. Then, in that case, or then unlawful contract. For example, I gave you the explanation also. Suppose, let us say, liquor trade was legal. Subsequently, the government introduces prohibition policy whereby sale of liquor or purchase of liquor is prohibited. Then, in that case, what was lawful hitherto becomes unlawful because of the law passed by the government. Then, in that case, as far as unlawful contracts are concerned, it cannot be enforced at all. Then you have also got what is called wagering contract. What do you mean by wagering contracts? Are Section 31, 32, or 33. When I come to Contracts Act, I'll discuss it. That means wagering contract is where the parties bet. I think nowadays, cricket matches, IPL matches, the T20 World Cup, then the other thing is 50-50 World Cup, then Women's World Cup, so on and so forth. Betting takes place on a very large scale. And please remember, when betting takes place, it depends upon an uncertain event which may or which may not happen, over which you do not have control. Then in that case, if that event happens, of course, it's enforceable. But if the event does not happen, you cannot claim that money which has been promised by the opposite side, because it's a contract which is a contract which is not enforceable. Wagering contract is supposed to be an unlawful contract and cannot. That's the reason people have lost lot of money as far as wagering contracts are concerned. And nowadays, online rummy also is coming in the your apps, in your cell phones. In rummy, people, I still remember a person who is a very rich person becomes a pauper because he goes on avariciousness and then bets on the, let us say, bets. Then what happens is there is a chance of winning or chance of not winning, or your three cards, which is played for money. Then in that case also it cannot be recovered. They are all supposed to be unlawful. Unlawful contracts will not be enforced by courts. Here, the first one is then in all these cases they are called wagering contracts. Then, as far as cancellation of suits or cancellation of decrees or cancellation of instruments and cancellation of decrees are concerned, suppose let us say the decree has been obtained by fraud, or the decree has been obtained behind your back. You are not made a party to the suit, though you are a proper and necessary party, or a declaration has been made which is against public policy, or a decree has been passed which is against the principles of law, or the instrument which is said to be executed by you is executed by fraud, misrepresentation, undue influence, coercion, duress, mistake, unilateral and bilateral. Then in that particular case, you can always file a suit for cancellation of that instrument, or the promissory note is obtained from you by putting you under threat of life or injury. Then in that case, you have executed the document. That document, you can get it cancelled under the provisions of section 31 to 33 of the of the Contracts Act, provided the question is, it is I'm sorry, it's not Contracts Act, sir. It is Specific Relief Act. You can get it cancelled as null and void by getting, and even if a decree is passed against you, you are not made a party, but the judgment which has been decreed is going to prejudicially affect you. Then in that case, you cannot file a suit for cancellation, because if you are not a party to the document, you cannot file a suit for cancellation under 31 to 33. Then what is the remedy open to me, sir? You have got section 34 and 35 of the Specific Relief Act, which speaks about declaration. Please remember, at the threshold itself, I tell you that a declaration is such a remedy. You will only have to frame it in your collar and then go about. But here, what is the type of declaration? When a right, position, cadre, or character is claimed by one person, when a position, status, character is claimed by one person, or a right is claimed by one person, and it is denied by the opposite side, then in that case, you can get your right declared through filing a suit for declaration. And most of the suits which are filed in civil courts today are declaration of legal heads. Please remember, whenever you draft a suit for declaration of legal heads, don't mention the word legal heads, declaration of legal status. If you mention legal heads, please bear it in mind, your suit will be dismissed. So he said, for a declaration of the legal status. Ramana, please mute, please. See, as far as declaration is concerned, again I repeat, 34 and 35 says, when a right, status, position, or character is claimed by one person and denied by the opposite side, then a suit for declaration is maintainable. Then the classic example which I can give you is, suppose, let us say, a document is brought about which prejudicially affects your rights, but you are not a party to that document. You cannot file a suit for cancellation. The only remedy open to you is to file a suit for declaration that that document is null, to declare that document as null and void. The second instance which arises, sir, suppose, let us say, a suit is filed for a daughter files a suit against the mother claiming declaration and possession of immobile property, and the property stands in the name of the mother of the party, and let us say she claims that 50% of the sale consideration has been paid by her, and the other 50% might have been paid by the mother. I do not know about it. Please declare me as the owner of the property. And she does not file any document in support thereof. How she has become the owner? Please remember, there is one enactment called Benami Transfers Prohibition Act. Here, Benami Transfers Prohibition Act is, which says whomsoever's name is mentioned as the owner and title holder, as far as the property is concerned, he or she is deemed to be the true owner. But any person who disputes the right of the person whose name is mentioned, he has to file a suit under the Benami Properties Transfer of Prohibition Act, which says that you, under section 3 of that particular act, you must show how you are the owner of the property, how it is nominally mentioned in the name of the other person, and you can get yourself declared as the absolute owner of the property by filing a suit under the Benami Properties Properties Transfer Prohibition Act. And there the question is, you can get a declaration that if the name of the other person is nominally mentioned and she is only your Benami dar, and you are the actual owner. Please remember, sometimes it's in a funny way, it's called not Benami, it's called Bemani. There is dishonesty. Here the question is, that is the reason, sir, why I could tell you is, and most of us, including me or anyone, we keep the properties in the name of our wives because we are scared of the income tax. But please, and more so if you are a government servant. The question is, nowadays, assets disproportionate to the known sources of income, you can be hard up. That is the reason Bahamadula Perla Gani, the Bavala Perla Gani property. Most of the politicians are getting into trouble because they are having all Benami properties there. And a latest example, the previous government also, a particular farmhouse belonged to the grandson. And the election affidavit that was given is the grandson had independent means of livelihood and he purchased the property. It's not a Benami transaction. Of course, I don't want to go into that. Here, the question is, and most of the suits which are filed today, are for declaration of legal. Please remember, suppose a lady loses her husband and she wants her name to be mutated in the revenue records or in the GHMC records or the cantonment records. They don't entertain that application because they say you go to the concerned court, obtain a civil from a civil court and obtain a decree that you are you are entitled for the legal status. Unless you obtain that, the question is we are not going to entertain it. That's the reason, sir. When you file such a suit, it is safer for you to normally how you write, sir. Most of you commit a mistake by saying that Mr. A so and so so and so, Mrs. A or whatever it is. Then and all concerned. That's what you write. The first different. Second one is preferably you make the GHMC represented by the commissioner also as a party. And in one of the paragraphs you say immediately on the death of my husband, death of the husband, I approached the GHMC for mutation of my name in the municipal records, but the GHMC directed me to obtain a legal headship certificate, succession certificate, or legal headship certificate from a competent civil court, and that is the reason. Since the defendant refused to entertain my application for mutation, my status and position is affected. I want to be declared as the legal status as the widow of the deceased. But please remember, one of the judgments of our own High Court, passed by Justice L. Narasimha Reddy, was that to say whenever you are asking to be declared to the legal status as far as the property of the deceased is concerned, you have to value the suit on half the market value of the property. Then alone you are entitled for declaration. Please remember, unfortunately, what has happened is I don't blame anyone. You have to blame the legislature. Why? Because though you have provided a parallel remedy under the Indian Succession Act, more particularly section 370 to 372, whenever debts are due by a bank or a financial institution or by anyone, you have to obtain a succession certificate under the provisions of 370 to 372. That applies only regarding money. But as far as property is concerned, it's absolutely silent. Perhaps the legislature avoided mentioning it. So the reason today is you can file a suit for declaration saying that you are entitled to the legal status as the widow and the children of the deceased. Then based on that, you can get everything done. The second contingency arises, sir, in the family courts mostly. Even our Supreme Court has said, even you can have multiple wives also, though monogamy is permissible in Hindus and bigamy should not be done. But what they said was, as far as family courts are concerned, the real problem comes when the deceased dies. South Gola అంటారు చూడండి తెలుగులో. The first wife claimed that she is the legally wedded wife. The second wife claimed that she is the legally wedded wife. The second wife claimed that she is the nominee as far as the terminal benefits are concerned, and she also is entitled for all the amount. And the first wife says, "Sir, the first marriage is still valid and subsisting. The second marriage is illegal. So the question is, she is not entitled for any benefits." So then the question is, both of them can go to the family court and get the status declared as to who is the legally wedded wife of the deceased. This is one of the contingencies. The other contingencies which arises is mostly, the most of the works and endowment institutions. There is a tussle always when the person who is the pontiff or the person who is the GR expires or is about to expire because of his ailment, he nominates his successor as his successor to that particular office. Then naturally the persons who are seniors in that particular institution, they claim, sir, the pontiff has committed a mistake. He has not made us as the successor. They question the right of the pontiff to nominate a junior most member as a successor. Please declare his nomination as null and void. Then another instance also arises, sir, with status, position, and mostly what happens is sometimes, of course, it is not indirectly, but here what happens is, suppose you file a suit for injunction, and let us say in that injunction suit you obtain a temporary injunction. In spite of the injunction, the other side proceeds with the construction, completes the construction. You are not helpless. You can always take the subsequent events into consideration and ask for a declaration that the constructions have been made in contravention of the injunction orders that has been passed by the court in IA number so whatever it is, and you can ask for a declaration that the illegal constructions should be declared as null and void, and I can also ask for mandatory injunction to remove the unauthorized structures. So declaration plays a very important part in our day-to-day life. And when you are not a party to an instrument, when you are not a party to the decree, you can always file a suit under section 34 and 35. But the essential ingredient of 34 and 35, I'm sorry, is section 50, a declaration is under 58 and 59 is you must claim a right, position, cadre, or character, and that should be denied by the opposite side. Then you are entitled for a declaration. That is what Article 34, Article 58 and 59 deals with. Then next one is we go to Article 60. Article 60 deals with to set aside a transfer of property made by the guardian of the ward by the ward who has attained majority by the ward's legal representative when the ward does within 3 years from the date of attaining majority. When the ward dies before attaining majority, then in this case, suppose let us say the guardian alienates the property of the ward without any justification, then the ward, after attaining the age of majority within 3 years, he can bring a suit to set aside that alienation not being binding on him because he has not chosen to sell it. Then ward's legal, that is, suppose the ward dies, then suppose let us say he dies after attaining majority, but he is married because in India early marriages are also permissible. Then his legal representative also can bring the suit to set aside the alienation. That is what Article 60 says. Article 61 and 62 is very, very important, sir. Here, by a mortgager, suppose a mortgager in the Transfer of Property Act, when I dealt with Section 60, I said once a mortgage, always a mortgage. That means where the mortgager, the right of the mortgager is to redeem the property, exercise the right of redemption, and the right of the mortgagee is to foreclose or bring the mortgage property to sale. Let us now come to the mortgager. As far as the mortgagor is concerned, so long as his right of redemption is not barred or not extinguished within a period of 30 years, he can bring a suit at any time to get back all his securities. And then when he exercises that right, it is called a redemption. A suit for redemption by the mortgagor against the mortgagee can be filed at any time within 30 years, provided that right has not been extinguished by a decree passed by the court in favor of the mortgagee. So 30 years period is given, sir, provided the right is not extinguished. Then we come to the mortgagee. As far as mortgage is concerned, Article 62 deals with that. Article 62 deals with that. It says to enforce the payment of money secured by a mortgage or otherwise charged upon immobile property. What about the creditor, sir? The creditor has to bring the suit whenever the mortgage money is due, whenever the mortgage money is payable, or whenever the mortgage money is enforceable, or when the charge on the immobile property which has been created by the mortgage becomes enforceable, he has to bring the suit within 12 years period. In this regard, sir, I tell you, we came across a very gross mistake committed by a junior civil judge. I think it is one of my earliest cases where what happened was the bank filed a suit for enforcement of mortgage covered by Article 62. Of course, primary documents which are taken by the bank is the promissory note and other documents. And the defense taken by the other side was, sir, as far as the debtor is concerned, I am only liable to 1/4 of the claim, and the guarantors are liable to the extent of 3/4 of the claim made by the bank because I only received 1/4 of the amount and 3/4 was received by the sureties or the guarantors. Then the lower court, what it did was, it had a nexus with the other side. Of course, I don't want to say that advocate is dead and gone also. Here, the court held that the suit is barred by limitation since under the promissory note, the suit was not brought within a period of 3 years, it is barred, ignoring the fact it was secured by equitable mortgage through deposit of title deeds. Then what happened was, I was appearing for the bank and the head office was banging me by saying, sir, you have not brought this fact to the notice of the court. Had you brought that fact to the notice of the court would have decreed the suit. Then I said, don't lose heart. There is a provision which the court has ignored, either by ignorance or not knowing the law. Then an appeal was filed before the appellate court. And before the appellate court, I started arguing from fundamentals. Sir, what is the definition of mortgage? How a mortgage is created? What do you mean by mortgage by deposit of title? What is meant by primary security and what is meant by secondary security? If it's a primary security alone on which the suit is based, then what is the limitation within which the suit has to be brought? If it is secured by equitable mortgage, what is the limitation within which the suit has to be brought? Then I said, sir, as far as enforcement of mortgage is concerned, it is 12 years period. Then the appellate court just laughed at me and said, sir, don't I know the fundamentals? Why are you explaining me right from the rudimentary fundamentals? I said, sir, I am explaining to you from the fundamentals because unfortunately I appear for an institution. I have to safeguard the interests of the institution because public money is involved. And I never knew that the suit will be dismissed by the lower court. If everything goes on well, sir, whether we recover or don't recover, there is a decree on board. Then what happened? The appellate court allowed the appeal throughout with cost, right from the lower court cost as well as the appellate court cost, and then said it is based on mortgage. So within 12 years, it can be filed, it can be brought about at any time. So Article 62 says when the mortgagee brings a suit for foreclosure, not only based on the primary document, but also on the charge created on the property against the mortgagor, he can bring the suit within 12 years period. That is Article 62. Then 63 deals with what is called by mortgage. I think Article 64 and Article 62 and 63 are almost the same. Then 64 is for possession of immobile property based on previous possession and not on title when the plaintiff, while in possession of the property, has been dispossessed. As far as recovery of immobile property, when you as the plaintiff, you are in possession of the property and the defendant, with the help of the mafia, had taken possession of the property, forcibly dispossessed you from the property, then within 12 years, you can always bring a suit for recovery of the possession of immobile property. That is what 64 means. Then 65 deals with for possession of immobile property or any interest thereon based on title for the purpose of this article, where the suit is by a remainder man, a reversion other than a landlord or a devisee, the possession of the defendant shall be deemed to become adverse only when the estate of the remainder man, reversioner or devisee, as the case may be, falls into possession. Here, as far as this Article 65 is concerned, when the possession has gone and to recover possession of the property which has gone into the hands of a third party, either a reversioner or any remainder man can bring a suit to recover possession of the property within 12 years. Then 66 deals with, then there's a case law on this also, sir. I'll deal with the case law where the question for consideration was whether the suit filed by, the citation is 2003 bracket 4 ILD. ILD means Indian Law Reports, Supreme Court Judgment 16, Supreme Court, where the question for consideration for was whether the suit filed by a daughter in the year 1969 challenged the gift made by her mother when after her death in favor of the defendants in the year 1936 as ab initio is governed by the provisions of the Punjab Limitation Customs Act or the Limitation Act of 63. The Honorable Supreme Court held that the suit was not barred by the time, in as much as the Punjab Act did not apply, but the Limitation Act was applicable. The Punjab Act was Punjab Act which was there was 1920. But as far as the Limitation Act is concerned, they say only the Limitation Act applies, and the daughter can always recover possession and recover the property. That was what was held in the leading case of 2003-4 ILD, page 16. That is the case of Ranbir Singh, RANBIR. Ranbir Singh versus Kartar Singh, KARTAR. So, with this, we shall stop. And now the interaction period. Yeah, I'll go ahead. That all right. Then we go to Article 66, possession of immobile property when the plaintiff has become entitled to possession by reason of any forfeiture or breach of condition. Here, suppose let us say for possession of immovable property, suppose any condition is breached, any violation is made, then in that case, when the forfeiture is incurred in the condition is broken. Suppose if, there is a clause for forfeiture, and let us say that condition is not fulfilled or the condition is broken, within 12 years, possession can be obtained. That is what 66 says. 67 says, when a landlord or to recover possession from a tenant, 12 years period is there. Suppose if you come under the Transfer of Property Act or you come under the Rent Control Act, within 12 years, at any time you can file a suit and then recover possession. That is what Article 67 says. Then we go to the next chapter, sir. Suits relating to movable property. Just excuse me. Article 67. Article 68. Suits relating to movable property. For specific movable property lost or acquired by theft or dishonest misappropriation or conversion. What do you mean? I deal with each one of them. Suppose a property is obtained by fraud, or property is obtained in dishonest by dishonest misappropriation or conversion or theft, then to recover that property, 3 years period is given. Suppose the theft property is already recovered and it is recovered from a particular person who has misappropriated it, used it for his own benefit, converted it into his own use, and the person who is really entitled to the possession of that particular movable property can bring a suit for recovery of that movable property within 3 years. Then next one is 69, sir. For other specific movable property, 3 years. Suppose let us say I hand over certain jewels to you to be kept with you because I'm going to Dubai, and as soon as I come, you must hand over those jewels. Suppose let us say that those jewels you do not return it to me, I'm entitled to the possession of the jewels or right to the particular jewels. Within 3 years, I can always bring a suit for recovery. The next one is 70 deals with for recovery of immovable property deposited or pawned from a depository or pawnee. Suppose in gold loans, I deposit the jewels and obtain a gold loan. Of course, nowadays, what the banks have also become very, very clever now. What they do is they give you only for a specified term. You must repay the money within 1 year, or you must pay it within 2 years. Then, of course, they charge extra interest if you cross 1 year. They suppose it's 10%. Then second year it will be 12%. Third year it will be 14%. But the goods do not belong to the pawnee. Always there's a right of the pawnee to get back the jewels. Within what time you must bring the suit, sir? You must bring the suit within 3 years. Then, to recover movable property deposited or pawned, afterwards brought from a depository or pawner for a valuable consideration. That is, to recover movable property deposited or pawned and afterwards brought from the depository or pawnee for a valuable consideration. Suppose, let us say, the pawnee or the person who holds your jewel sells it to some other person. Then you can recover possession from the third person to whom it has been delivered, and you must bring the suit within 3 years. This is as far as suits relating to movable property is concerned. The next chapter is part 7, that is suits relating to torts. Here, for compensation for doing or omitting to do an act alleged to be in pursuance of any enactment in force for the time being in the territories to which the act extends. That is, when the act or extension takes place. Suppose, let us say, the act applies to certain states. Here it is said the compensation for doing an act or do an act alleged to be in continuance of the continue to be in pursuance of an enactment in force for the time being in force, the territories in which the act extends. That is compensation. Suppose wrongfully it is held by some person and is not delivering it to you, you can claim compensation under the provisions of section 72. Then 73 is for compromise for for compensation for false imprisonment. What do you mean by false imprisonment? False imprisonment is, suppose let us say a case is foisted against you, and let us say you are not committed any crime, but still the police prosecutes you and charges you with that particular offense, and you try to you face the trial, and the trial you are acquitted, and all the charges are disproved. Then in that case, you can ask for compensation by the from the person who has launched the complaint against you, launched the FIR against you, and initiated the process of the criminal proceedings against you, and that is for false imprisonment. Then a false imprisonment. Suppose, let us say, you have been convicted also, and let us say later on in appeal or somewhere you succeed. Then for that you can claim compensation within 1 year. Then next one is malicious prosecution. Malicious prosecution, that is Article 74. It says malicious prosecution means where with malice, where with ill motives, where with evil intentions, the police has prosecuted you without any basis for proceeding against you. You have been acquitted by a competent criminal court, and right from the appeal and even the high court, you have succeeded. You can make the police liable, responsible. As far as malicious prosecution is concerned, not only make the police, but also the de facto complainant who has lodged the complaint and claim damages from the opposite side, and that for that period, 1 year period is mentioned, limitation. Then for compensation for libel, what do you mean by libel, sir? Libel means any printed matter, any written matter, any pamphlet, any lithograph, any cartoon, or or degrading you and trying to defame your character in writing, in the eyes of your public, in the eyes of your relatives, in the eyes of your friends, it is called a libel. As far as a libel is concerned, whenever a libel is committed, or let us say, then it is 1 year. When the printed material comes to your notice, within 1 year you can ask for damages or compensation. Then slander. What do you mean by slander, sir? Anything said by words of mouth, contact, or by implication, which degrades your reputation, which degrades your integrity, which degrades your respect amongst your friends, relatives, etc., and where your integrity takes a beating. Then in that case, you can always proceed against the other side who has uttered those words defaming you, and under Article 76, you can bring the suit within 1 year. I think perhaps now it's a political battle which is going on. I think most of you remember the case of Rahul Gandhi, who made some aspersions against our Prime Minister. Both criminal case was filed and a civil case also was filed for defamation. Then in that particular criminal case, the union government succeeded in getting Rahul Gandhi imprisoned. But later on, the Supreme Court found that it was a cooked up story, and the criminal proceedings does not lie as far as Rahul Gandhi is concerned, as far as defamation is concerned. But please remember, now cricketers are also facing that, the question of match fixing. In match fixing, you say you have taken money and fixed a match and fixed the decision of the match. Then the question is, some of the cricketers also were banned. But sometimes you make false allegations which you are not able to substantiate. Then in that particular case, you can make the other side responsible, file a suit for defamation, and then recover damages. Then Article 77 deals with for compensation for loss of service occasioned by the seduction of the plaintiff's servant or daughter. That is for compensation for loss of service occasioned by the seduction of the plaintiff's servant or daughter. Please remember, these are all things which are going on day to day. Here, sometimes what happens is most of the victims are the servant maids, or let us say the wife of the particular person. And let us say seduction takes place, rape also takes place, where they're sexually exploited. And please remember, they become a victim. And let us say because of that, so that the matter may not come out, a person is dismissed from service or suspended from service. Then in that case, the plaintiff's servant or let us say daughter is a victim of that. Then a claim can be made for compensation within 1 year because of loss of service. Then 78 deals with for inducting a person to break a contract with the plaintiff. There sometimes what happens is evil forces are always there. There they say you break the contract, I will look into all those things. Then you forcibly compel a person to break the contract with the opposite side. Then the person whose contract is so broken can bring a suit for compensation within 1 year. Then next one is 79, deals with compensation for an illegal, irregular, or excessive distress. the date of the distress. Distress means, suppose let us say you lock up all the doors. You know, there is one movie which had come, Chettis Gante. In that, what happens? The entire house is locked. You are not allowed to go answer your calls of nature. Your phone is disconnected. You are not able to contact the opposite, contact your friends and relatives, and then you are in distress, or you are put under threat of fear and injury. Then, in that case, you can always ask for compensation. Then you can ask for compensation for the illegal, irregular, or excessive distress. Then next one is 80. Is within 1 year you can do it for compensation for wrongful seizure of mobile property under legal process. Suppose let us say your mobile property is seized under an illegal process at the instigation of someone, or the police is influenced in that particular matter. Within 1 year, you can file a claim for compensation. Then 81 is for by executors, administrators, or representatives under the Legal Representative Suits Act 1855. That is the date on the date of the death of the person wronged. Suppose let us say your father has been wronged, your father has been victimized, then the son or the children of the deceased can always bring a suit for that is by either the suit can be brought by the legal representatives, executors, or the administrators within 1 year. Then 82 deals with administrative representative under the Indian Fatal Accidents Act. Suppose let us say the executors, administrators, or the legal. Suppose let us say your father dies in a fatal accident and the compensation is not paid. You can always bring a suit. The executor or the administrator or the legal representatives can bring a suit for for a recovery of the amount that is payable as compensation on account of the disease. Then within 1 year the suit has to be brought. I think we'll stop with this. That is till 81 we have finished. The rest of it I shall try to complete it tomorrow. The interaction period, sir. One madam by name Salina had asked some queries. Let her ask the queries by way of interaction, sir, because we could not solve it that day because it was not clear. Miss Selina.
You can go into the questions.
Interaction period, please.
Sir, if the Binami property is proved by the person, then it will be again given back to him.
It will not be given back to him. It will be given to the person who is the actual owner of the property, not to the Benamida.
Okay, it means again the title holder will be the owner of the property.
He will become the owner, but the test under Section 3 of the Benami Transfers Act is very, very strict. There you'll have to show the source of consideration, how we have acquired the property, whether you have taken a loan, or what is the loan which is obtained by you, whether you obtained a loan from your employer, what is the loan which is applied by you, what is the property you sold to acquire this property, then why did you keep it in the name of your wife or some Benamidar, and what are the circumstances under which you have made the Benamidar as a part. Then next one is you will have to show the means of the Benamidar. What was the means? She was only a housewife. She didn't have the money. Even the Sridhar she did not have. The entire money was spent by me. All these tests you will have to satisfy. To be precise, Section 3 of the Benami Transfers Prohibition Act, you'll have to go through, sir. Pardon, sir?
So in such a case, if the title holder do not have a proper source of income, and the person who has registered the property in the title holder name have shown the proper source of income and all these details, then he can get it back.
It will be declared as a Benami transaction. The original owner gets it back.
Original only will get it back.
Yes, but please remember that's the reason why a word of caution also. You may have love and affection for your wife, but so long as the relationship is good and it's not strained, it's fine. But once the relationship gets strained, the wife will neck you out of the house.
Okay, thank you.
Right. Yes, Mr. Badesap. I mean, Mr. Sam, you have raised your hand.
Yes, sir. Good evening, sir.
Good evening.
Sir, just under the Binami Provision Transfer Act, you say if both the owner and the Binami other person has passed away, the LRs can claim under the Binami, sir?
They can definitely do it as legal representatives, sir. But against whom you are going to claim?
Against the Benami holder, not the owner. The
but
owner
again this legal representative enjoy a dual capacity, sir. They become the legal heirs not only of the true owner, but also of the Benami. Suppose it's a husband and wife transaction. But if it's a third party, let us, I think what you're trying to visualize is, suppose it's a third party, the LRs can always maintain the suit on behalf of the deceased also, sir. Are you able to understand?
Okay,
But-
that is what I meant, sir. It is
but
a
the
third
test-
party,
test
not related
there-
to the owner.
But kindly look into section 3, the test is very, very severe. You will have to prove and establish your means of livelihood, or the person who was dead, his means of livelihood, how he has raised that money, how the consideration was paid, what was the means of the opposite side, whether the other person had means to purchase the property, or whether it's a transaction which can ultimately called as a nominal transaction, and the name of the wife is nominally linked to it, or the name of the third party is nominally linked to it. This is happening regarding politicians now, sir. That is income disproportionate. I mean, means disproportionate to the known sources of income. Yes.
So we have to prove the income status of
just
the person.
kindly go through section 3 of the Benami Properties Transfer of Prohibition Act. Section 3.
Okay.
Yeah.
Yes.
And sir, family member certificate, whether we used to get it from the court when it
No,
is
sir.
rejected
Actually,
for
there is previously what used to happen is the MRO used to issue what is called family member certificate if they are government servants. But as far as you and me are concerned, we are not government servants. So the question is, we will have to only go through the court. Revenue officials cannot grant legal heirship certificates. There are various judgments also on that. And to quote the correct judgment, it is Justice VVS Law's judgment somewhere in 2014 or 15, where he says revenue authorities cannot grant legal heirship certificates. Only a civil court which can grant it.
civil court. Okay.
Yes.
See. Thank you.
But don't use the word legal heirs. Use the word legal status. If you use the word legal heirs, your suit will be dismissed. And make a pro forma party, either the GHMC or the government, as one of the parties, so that there some semblance of contest is there and your right is denied. Then only you are entitled for the legal status, not otherwise.
Okay.
Yes, next, sir. Mr. Vasantara.
Good evening, sir.
Good evening.
This is the question regarding the specific performance, sir.
Right.
My client purchased a property
Yes.
under agreement of sale.
Yeah. Go ahead, sir.
From also he has also purchased the property under agreement of sale, but he did not get the register sale.
Pardon? Did not?
Did not get the register sale deed.
Right.
He also got the property by agreement of sale.
Right.
The original was denying to execute the.
See, the question is, you are covered by 53A of the Transfer of Property Act to say that on the agreement of sale, a document has been executed in your favor and you have performed your obligations and you are in possession by virtue of 53A of the Transfer of Property Act and you have changed your position which you would not have done otherwise than through the agreement of sale. And please remember, now under the present Act, under Section 17(1)(b), every agreement has to be in writing and has to be duly registered.
But it was mentioned that the possession was delivered.
Then in part, if possession was delivered, your agreement should be registered actually.
But what happened now? The register agreement was not registered.
If it is not registered, then under Section 49 of the Registration Act, you can say for a collateral purpose, it can be gone into the nature of the transaction.
Only 53A, please explain again, sir.
53A is part performance, sir. Suppose I execute an agreement in your favor, I put you into possession of the property, you change your position which you would not have done but for my act of delivering possession, and you have improved upon the property, you have acted pursuant to the agreement of sale, and the vendor has kept quiet when you have carried out improvement. You can always plead and say that under part performance, I have been put into possession of the property, though for want of a registered document, it shall not be a bar as far as enforcing the agreement is concerned. So specific performance like so 53A, you'll have to say you have done something relating to the land, either entering into possession, improving the property, developing the property, or constructing on that property based on the agreement of sale. Then part performance applies. That is why it is said it is based on what is called the English law statute of frauds. That is, an instrument cannot be statute cannot be made an instrument of fraud. But in England, they say the equitable estates are recognized. That means, suppose even if an agreement of sale is there, you have been put into possession of the property, though it is not reduced to writing, or though it is not registered or under seal, they call it in England. The law protects you because of your possession being delivered to you. So the question is statute requiring certain formalities to be completed. Even if it is not completed, law presumes a genuine transaction intercede parties. But in India, we don't recognize equitable estates. We recognize only legal estates. That means you get a valid document executed by the vendor and then you become the owner of the property. Then you can claim rights over the property. But 53A says is if possession has been delivered to you pursuant to the agreement of sale and you have done something relating to the property, taken possession of the property, you are ready and willing to perform your part of the obligations. By being in possession, you can claim part performance and say that my possession should not be disturbed. Are you able to understand, please? That's what 53A says.
Then the last purchase has to want to file the suit. They have to file the original order and the subsequent agreement of sale purchase also have to be.
You are better to give a notice so that you may know the defense of the other side.
Already notice was given that original order, title order was.
Then his legal representatives are not personally liable, but the estate which comes into their hands are liable, sir.
She yellow, but she refused to take the notice.
Pardon?
The original owner refused to receive the
then
notice.
that is a good ground for you to say that refusal is there because he has to execute the document. He avoided to do it. That's why under Article 54 proviso, you can say that refusal is clear. So I am come within 3 years, not from the date of agreement, at least later.
Okay, sir. Okay.
Yeah.
Thank you, sir.
Welcome.
It was clear.
Yes. Any more questions, please?
And sir, regarding declaration of the title, the court fees will be half of the market
See, if
value.
it is regarding immobile property, you want declaration regarding the property, you will have to pay half the market value. That then alone your suit will be numbered. That's the reason I pointed out, saying that the Indian Succession Act has omitted to mention this provision in the Succession Act. If they had done it, these problems would not have arisen. Why? Because it gave scope to the learned judge to pass an order saying that half the market value is to be paid. It's very, very unjust also. Why? Because a person who has lost her husband, that the state becomes a participant in the booty. State gets half the market value as court fee. That should not be the case. Unless they amend the Indian Succession Act, they should, unless they amend the Indian Succession Act and include immobile properties also there, perhaps this problem would not have come. Because when you address the GHMC, what they say is obtain a succession certificate from the court. Succession certificate is granted only regarding debts, money which you have to receive. But as far as the succession certificate will not be granted regarding immobile property.
And even for the partition also, it is half of the market value, sir?
No, sir. As far as property is concerned, if you are asking for partition, if you are in possession of the property, you only pay a fixed court fee of 200 rupees or whatever it is. But if you are not in possession of the property, then you have to pay the court fee on your share. That is 3/4 of your share. Suppose you are entitled for 1/4. 3/4 into 1/4. That is 3/16 of the market value. That will be the value for the purpose of the suit. Are you able to understand?
Yes, sir. Yes, sir. Thank you.
You make a mistake because you value at 3/4. No, sir, it's not correct. You mention 3/4 market value, no doubt about it. But as far as court fee is concerned, you say if you see 34(2), the question is very, very clear. 3/4 of your sharing, 3/4 of the amount included in your share. That means you are entitled for 1/4, 3/4 into 1/4 will be 3/16 or the market value. That will be the value for the purpose of the suit. But normally, no one pays the entire court fee, sir. What they do is they say they are in joint possession. But nowadays, the courts are raising an objection. What is the proof that you are in possession? Please remember, suppose in Mr. Natraj, you are staying in Chennai. Here, the suit has to be brought in Hyderabad. But your brothers and all are in possession. Doesn't mean you have lost possession. You are in joint possession because your right is always there. But the courts are very, very strict to say, try to establish your acts of possession to say that you are in joint possession. Suppose
joint possession means only 200 fee.
200, sir, fixed court fee.
Okay.
But what we advocates do normally is we pay the court fee at 200 only. If the court frames an issue later on, we'll see. Because if not, you will not get your fees.
Okay, it is in two extremes. Both half and
Yes, sir. Next, sir. Any more questions, please?
Sir, this is Mohammed, sir.
Yes, sir. Yes,
Sir,
Mr.
son can file suit against the father of for removable property, unremovable property.
Sir, now as far as property is concerned, there is no love loss, sir, whether it's father and son, father and daughter, or so on. So, because in our Tamil, there's a proverb, they say, suppose you say money, 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 or property, even a dead body will come alive and say, where is the money, where is the property? There's no love loss now, sir. Gone are those days when we had family cordiality, father and son relationship, father and daughter relationship, all these things.
No,
Now,
sir. See,
yes, Mr. Saab, Bade Saab.
my question is, sir, that properties belongs to father only. He only purchased the property, but unfortunately, son has filed a case against the father
For what?
for the immovable property, sir.
That is for partition.
There is no partition, sir. He only ఒక కుటుంబంలో నలుగురు ఉన్నారు సార్. ఇద్దరు అన్నదమ్ములు, ఇద్దరు అక్క చెల్లెలు.
సరే.
ఓకేనా? తండ్రి గారిది ప్రాపర్టీ. తండ్రి బతికుండగానే ఒక కొడుకు అతని మీద కేసు చేశారు.
That suit will not be maintainable with self-acquired property so long as the father is alive, sir.
ఏసి అతని మీద డిగ్రీ తెచ్చుకున్నారు.
Sure.
లాస్ట్ టైం మనం డిస్కస్ చేసాం కదా సార్.
కరెక్ట్ అండి.
సో అది కంటెస్ట్ చేయాలంటే ఏం చేయాలి?
Contest చేయాలంటే to say that self-acquired property, the question of succession will come only after the death of the person whose property it is there. So long as that person is alive, the property cannot be claimed unless this person says the entire consideration was paid by him and the father's name out of respect is mentioned. Or let us say the father has acquired the property from out of the money provided by the son. All these things are very, very difficult, sir. That's why it's a Benami properties transfer of Benami transfers properties act, where they say suppose it's only a Benami and you are trying to, you will have to say the father, it doesn't belong to the father at all, and the father took the money from the son and they kept it was allowed to remain in the name of the father because of the affection and because of being the elderly member. Please remember, nowadays all sorts of differences can be taken, sir. Even if you are willing to give it up, you're better off will not say come on, file a suit. So these are all things which are happening,
but in the plaint, he did not mention that how can he obtain the property from the father.
That is a crucial mistake committed.
And one more thing, he appointed one more advocate for the father, and he given the written statement in that whatever the allegations made by the son, he was accepted.
It must be a collusive transaction to avoid something, sir.
And that was the decreed in 1989.
Perhaps it must have been done to avoid creditors, sir, if I'm correct.
Sir, how can we challenge the degree, that the fraudulent degree?
The fraudulent degree, if you are a creditor, you can challenge it.
Because I am the one of the interested person.
If you are the interested person, you file a suit for partition and also ask for cancellation of that or declaration that that particular document is null and void, that decree is null and void. You will have to go under 34 and 35.
In that, we have filed that partition suit that OS has dismissed, as well as AS also dismissed it, sir.
I know. You are now in second appeal.
Yes, sir. Yes. The same thing which in judgment the judge has said that before death of father there is no property in his name. So your request on the partition, it cannot be maintainable. So your suit has been dismissed.
It's an arguable point, sir.
Sir.
Yes, next, sir. Any more questions? Can we?
Sir, regarding contract, sir, void contract, you said unilateral and bilateral.
No, sir. As far as void contract is concerned, I never said a unilateral and bilateral mistake, not contract. Unilateral and bilateral mistake, it is voidable, it's not void. But as far as a contract with a minor, contract with an unsound person, contract with an idiot, contract with a person other disqualified by any law for the time being forced is void ab initio, or a contract without consideration is supposed to be void. Are you able to understand, please? Void is not enforceable at all. But as far as voidable is exercisable at the option of the person whose consent is not free.
And if a contract is only completely one-sided?
If it's one-sided, then the question is it can always be challenged, sir, by filing a suit, by saying that there is no fair play involved.
Thank you.
Right. Any more questions, please? Can we wind up?
Can we conclude the class for today?
Yes, sir.
Yeah,
Sir,
please,
one
Sam, go ahead.
question, sir.
Yes, Mr. Sam.
Sir, Article 38, you said the bill of exchange is a foreign document. The limitation period is 3 years, no, sir?
Yes.
So if there is a fraud that happens in letter of credit or the exporter, where he has to file the case, sir, that 3 years? Is it in arbitration or where?
Not arbitration, sir. That question is you'll have to challenge the bill of exchange as being null and void because no consideration in that.
Which court, sir? Is it in tribunal or which court?
There is no tribunal for that. There is no arbitration in bill of exchange, sir.
Because bill of lading is a
bill of lading, suppose there's an arbitration clause, you will have to invoke the arbitration clause by asking the other side to nominate an arbitrator on his side and your side one arbitrator and one referee whose verdict will be final.
But he is a foreigner, no, sir? I mean, from other country.
I'm saying foreign bill, sir. I'm saying, I didn't say foreigner. I said foreign bill. Foreign bill is, suppose Mr. Sam, you go to foreign country, you send the bill from there. Or let us say the transaction is done in India, but you're temporarily in Dubai or Muscat or somewhere. But it's a bill which is executed or done here. Acceptance is done in India. Then that question, that limitation of provision comes. Not otherwise. Foreign bill means the question is, suppose you are due any money to a foreigner for supply of goods or delivery of goods or whatever it is. Then in that case, it is 3 years. That person can file a suit against you in case you don't pay. Foreign bill, don't mistake that it's a bill of exchange. No. Foreign bill means it can be for purchase, it can be for acquiring anything, or so on and so forth. Then if price is not paid within 3 years, a suit can be brought, sir. Don't mistake it to be a bill of exchange, sir.
I was actually referring to that international transaction.
But bill of exchange is not now almost gone. Bill of exchange is not found today in real practice. Even your check can be called a bill of exchange because there are 3 parties: drawer, drawee, and the payee, isn't it? The check is drawn in the name of the drawee, payable by the payee. It is drawn by the drawer in favor of the drawee, payable by the payee. So there are 3 parties. So the question is, even a check can be called as a bill of exchange. It's a species of bill of exchange.
Okay, sir.
Any more questions? Can we wind up, please?
Sir, market value is accepted where from?
You will have to obtain from the sub-registrar officer the market value of the property.
Oh, okay.
Any more questions, please?
Can we conclude the class for today?
Okay. Thank you.
All right. Thank you much. Sir, पूछना उन्होंने.